Hello, Trayvon Martin, George Zimmerman fans. I'm going to discuss this particular video I'm about to play because it is a significant hearing that was held today. Let's see, it's July 9, 2013. And the reason I'm going to go over it is you may have heard in the past that Trayvon Martin's cell phone data was obtained, and it was just before trial was to commence, I think June 4, that the defense finally got this data, and it was one of the reasons that the defense asked for a continuance because they didn't have enough time to prepare discovery, to examine the data, talk to witnesses, authenticate various text, photographs, whatever. The judge denied that continuance and said, let's get to trial. So here we are in the middle, not really the middle, almost to the end of trial. The state rested its case in chief. The defense indicated that before this hearing today, that they would rest the defense case on Wednesday, which is today, I guess. The But this hearing was explosive. Everybody got upset, and so now I do not think the defense will rest on Wednesday, July 10. I think they'll probably go through Thursday, and closing arguments maybe on Friday. I don't know. It's all academic in a sense because it doesn't really matter for purposes of our discussion right now. I'll advise you ahead of time or warn you, whatever, that I don't have any notes. I'm just ad-libbing, so to speak, talking off the top of my head. So if my grammar gets sloppy, that's my excuse. Plus, today's proceedings, which here in San Francisco I have to get up at 5 a.m. to prepare to listen to the trial, watch the trial on the internet, because court commences at 9 o'clock usually. So that means I get up an hour before, get a coffee, and get everything set up. And so that's why I have to get up at 5. And I have been doing that for 5 weeks, I think, with jury selection. But the other thing is today was an extremely long day for everyone. Court started at 8:30. They heard some preliminary matters that went into actual trial time, which upset the judge. So she called the jury in, who was waiting in the jury room, and they had trial with the intent to pick up these motions that one of them I'm going to be discussing here at 4 o'clock. And court went until 10 o'clock at night, which was an extremely long session. I've never seen court go that long. I've never experienced that. I've never heard of lawyers having court until 10 at night. So this was remarkable, simply in that context of how long court is in session. Actually, law in motion or motions heard took longer than actual trial today. If you include beforehand, before court, and then after commencing at 4. Anyway, the issue here on this motion that I want to play involves the defense, Mark O'Mara, Don West, trying to get in the cell phone data that was retrieved off of Trayvon Martin's phone. Some of you may have heard that very explosive material, and it's arguably why Sabrina Fulton and Tracy Martin had to limit their testimony, because if they opened the door, as the phrase goes, and I'm sure some of you have heard of that, if they opened the door to say something like, oh, he was such a nice boy and never fought and whatever, that that would entitle the defense, Zimmerman in other words, to inquire or impeach that testimony, including what was on his cell phone, the text about fighting and doing drugs, smoking pot, whatever. So the witness, the expert, is a Florida lawyer named Richard Connor, I think, and he is going to testify about his inspection of the cell phone and what he found. And then that's going to be followed up with Don West, who is handling this motion, discussing why this material should be admitted into the trial. One of the arguments he makes, and which I had mentioned before, was when the state had, I think her name was Fulgate, Ms. Fulgate, testify from her notes as a physician assistant treating George Zimmerman, that her notes indicated that he was taking MMA, mixed martial arts, MMA training. And you may recall Bernie really worked that up and said, oh, MMA training, and the implication being that Zimmerman was a fighter. He wasn't this innocent, defenseless guy that didn't know how to fight and whatever, because the main argument with the state is that Zimmerman was the aggressor. He knew how to take care of himself. He was certainly not frightened by Trayvon Martin, and they basically got in a fight. And then when Zimmerman saw he was losing, that's when he took out his gun and shot him. So this MMA entry on the physician assistant's notes was a significant bit of evidence. Obviously, the defense should be able to counter that perception that the prosecutors instilled in the jurors' minds that this guy is some kind of mixed martial arts fighter. Okay, let's get to the video. At times I'm going to double the speed on the playback, simply because that it'll be shorter and you won't have to sit through the entire hearing, which was, I think, about 2 hours long. Okay, so let's get to it, and I'll provide commentary as we go along. I'll pause it, talk about what was just said, and that's it. Okay, let's get on with the show.
Okay, so you're finished with your argument. All right, I'm going to reserve ruling on this, and I'll let you know when we reconvene at 8 o'clock in the morning. The next issue is Mr. Connor, the proffering of his testimony. Could you please tell me what is it that Mr. Connor is going to testify to in a few short words? Because if he's going to testify to, you're seeking to have him testify to what was found on Trayvon Martin's phone. I can just look at what it is that you're seeking to have introduced without having his testimony proffered and make that decision. Is that what he's going to be called for? Is that he was able to...
Okay, what the judge is asking is, remember, it's 8 o'clock at night here, and this is about a 2-hour hearing, this part. What the judge is asking is, hey, do we need to have this hearing? Because if you're just trying to get in the cell phone data, just show me the cell phone data and I'll listen to argument as to why it should come in, and I'll make my ruling. So if the expert is not necessary, we don't need to call him. So that's what she's asking Don West, is all this necessary?
Obtain certain information, either text messages, videos, or pictures off of Trayvon Martin's phone?
That's correct.
Okay, can I please see what it is that you're intending to introduce through him? And I don't need to hear his proffered testimony.
Yeah, I believe there needs to be a proffer of his testimony.
No,
so
there needs to be a proffer of what you're seeking to introduce by way of pictures through him. I don't need to go through.
in order to explain it to the court so that the substance is clear, it's necessary for Mr. Conner to talk about how and where he found the information on the phone.
All I need to know is that he found information on the phone. That doesn't go to whether or not that information is admissible.
Okay, this is important, people, because not because of what they're talking about in the sense of do we need this expert or not, but later on, towards the end, the judge contradicted herself. And I think, that's just my opinion, that's why she continued the matter and recessed court and stormed out of the courtroom at the end, because she realized she had contradicted herself. Mr. West is saying that, well, I need to get this expert in here to testify the methods he used to find this data, where he found it, in what folders, in what kind of apps they were in, and basically his methodology. The judge is saying, well, no, you don't need to do that, just show me the data. Well, at the end of this hearing, the judge contradicted herself because she said, I have a problem with authentication. I don't know if an 8-year-old possibly accessed this phone, and she was the one who sent all these texts, these incriminating texts, and or she was the one, or someone else didn't take the pictures of the gun, the marijuana plants, and all these things. So she was saying, I don't know where all this came from. And this is exactly what she said she didn't need to know right now, what she's talking about. So that's interesting that she contradicted herself.
His testimony of what procedure he did to find something on the phone is not the relevant factor for what you're trying to do. What you're trying to do is introduce certain either photos, emails, or text messages. That's what I need to look at. So can I please see what it is that you would be seeking to introduce by way of evidence through Mr. Conner?
Yes, I can outline that, yes.
Well, I'd like to see what it is. You have it there in your hand.
Yes, Judge,
Okay.
I do. I have several pieces of information that were obtained in different ways from Mr. Martin's phone. As the court is aware, this issue is actually ongoing because of the way the discovery has gone in this case. We got a report from the state on June 4th, and we're still trying to process that. But from information that we were provided in discovery sometime in late February, Mr. Conner was able to do some of the extracting. So there are two main issues. One relates to several conversations by Mr. Martin attempting to acquire a firearm.
These are conversations that are audio conversations, or are they written?
They are text messages
Okay.
that were obtained from his phone, but that's a secondary issue. We'll have a separate exhibit.
Well, no, it's not secondary because that's an authentication issue. If it is his if it's his voice, then that may not be an authentication issue. If it's a text message, it is an authentication issue.
Yes, and I need Mr. Conner to talk about authentication, but to cut to the chase, if you will, on the crux of the matters that relate to the it's Mr. Martin's text messages about being in a fight, about the effects of that fight on him, that he got into a fight, that he lost the first round, won the second and third round, bloodied the guy's nose, wasn't done with him yet. A confirmatory text message with another friend, Michael French, confirming that he was in the fight and explaining that he, meaning the opponent, got more hits in the first round because he had me on the ground and I couldn't do anything. A Facebook post from Mr. Martin's half-brother, Demetrius Martin, asking Trayvon Martin, when you going to teach me how to fight? And the first text message I was paraphrasing, the one is to a person named Lavandria. I have the text of that here. I have the, this was in a hidden file in Mr. Martin's phone that was password accessible only, in addition to the password required or swipe code to get into the phone. So this was a second level of access that was necessary. I can mark them individually or as a composite. One came from the hidden text messages that Mr. Connor found. One came from a hidden Facebook post that was in an application that was hidden. And then another from the Cellbrite extraction report from Michael French. So I would like to offer Mr. Connor's testimony to explain how he was able to access the phone and what steps were taken that would show that really, realistically, only Trayvon Martin could have created these texts or engaged in these conversations.
Okay, state.
So I'll mark these here for the court to review.
Okay, we'll mark them as composite exhibit NN for the defense, for identification.
That is a more detailed text explaining about the fight that he had just been in and the 3 rounds, etc. The other one has to do with the sort of confirmatory text message to this fellow Michael French shortly the next day. And then, of course, the separate Facebook posting by Demetrius Martin to Trayvon Martin's Facebook asking when he was going to teach him how to fight. We also can authenticate another way, if the court wants me to go ahead and proffer that as well.
There's so much paper in this case. And remember, they've had a full day of court, so it's easy to lose things. It's been 12 hours in the courtroom they've had today. And literally they have to pack everything up every night and cart it home or to the office and then bring it back in the morning. What Mr. West should be using is what I have is it's called a file sorter, but it's like that thing he's holding right now. Well, not the binder paper, but the it has like numbered tabs, or you can choose letters of the alphabet, and you can put everything in categories. A, B, C, D, E, F, G, H, etc.
Did you have some others that I have the CV of Mr. Carter marked as 00.
And then you can put a post-it note up front with a little index, handwritten index, saying what is under each letter. So white could white. I'm thinking that how Don West looks like what's his name? White in the Breaking Bad. So Walter White, and anyway, so you just put like under A you would say are the text, under B would be the pictures, C would be the expert CV, whatever, just so it's all easy to find. And then you could label that particular binder for the day, the sorter, the expert motion on the cell phone data. And then when there's another motion, you just use a different binder, or the same binder, but just remove the post-it notes if you want, and whatever.
For identification for the defense, was double N, the three sheets that you gave me, all that you're seeking to have introduced through Mr. Connor?
Well, that's the stuff that relates specifically to the fighting. And then there are other exhibits that relate to the gun. And I'd like to, if we could, deal with the fighting issue, because that's the crux.
Okay.
That's the crux of this.
Then-
Let me assemble, I guess, the other material on the gun. That consists of, Your Honor, some pictures that were retrieved from Trayvon Martin's phone that were taken by that phone of that show a hand wrapped around a firearm, believed to be a Smith & Wesson firearm. We'll provide that. And then there are a series of conversations that occur.
Okay, I'm going to try doubling the speed of this so that we can get through this faster, because as you can tell, West is a slow talker, not a low talker, a slow talker. Right.
Around February 18th, just before Martin is coming to Sanford, Florida, where he has several conversations with several people attempting to acquire a firearm.
Mr. Guy, you want to address defense exhibit double N for identification?
Sure, just I don't have a copy of it.
I can provide Mr. Guy another copy. He does have this information. In fact, we got it from him.
Judge, we do have it, but it's in volumes. I didn't know specifically what they pulled out. Judge, we're right back where we started with the motion in limine that I filed before the trial. In the Munoz and Singh case, where in an instance where two people do not know each other, specific acts are inadmissible because they don't help the jury with the reasonableness or apprehension that a defendant may feel because he has no idea who this person is. This is not reputation evidence, which otherwise might be admissible under these circumstances. Furthermore, in addition to an authentication issue, how do we know what whoever wrote this is talking about? I mean, this could be a verbal fight, this could be a play fight, this slap fight. We have no idea. It would completely mislead the jury and be prejudicial. It's the kind of thing that is inadmissible for a reason. It would do nothing to aid this jury. It doesn't tell us about Trayvon Martin. It certainly doesn't tell us about what George Zimmerman knew about Trayvon Martin, and that's why the court granted, I think, this initially, is because there is no evidence that they knew each other, and therefore specific act evidence, which this is completely inadmissible. If I can just touch on the gun, if the court will allow me to, or not.
I really haven't heard the
Okay.
argument or proffer from Mr. West about that. He just mentioned that he intended to, so I'd rather you wait.
I guess in summary, my objection is it's inadmissible. It's rank speculation as to what any of this means, who sent it, what it was about. If you look carefully at these, there's no context to them. They're pulled out at certain times, and we don't know any conversation that surrounded them. It's just completely misleading, and therefore it shouldn't be allowed.
Now remember that the state introduced Folgate's physician assistant notes and made a lot of noise and looked at the jury to see the reaction when she testified to the MMA training notation in the files. That left a lot of speculation. It told nothing about what Zimmerman was all about. The defense was forced to call that witness that where Zimmerman actually had attended the gym, and remember that he received a very low, I think a 0.5 rating on a 1 to 10 scale. It said that he was basically fat and not capable of doing anything, and on and on. So that obviously misled the jury. So fast forward a few days, here we are now. The prosecution is saying, oh, these texts will mislead the jury and speculation and on and on. So it's a contradictory argument.
And I provided the Munoz and Singh case to the court
Can I have that?
prior to trial. Singh, S-I-N-G-H. That's all I have regarding the text, regarding my.
Any further argument from you, Mr. West, regarding the text?
Yes, I have a substantial argument, Your Honor. But I want to proffer Mr. Connor's testimony if the state claims that these are out of context, because we can put them in the context in which they were on the phone.
Well, I'll allow you to proffer as long as I don't go into a long proffer about Mr. Connor's qualifications and his background and all of that. I would like to keep it just to where he found this for the purposes of the proffer. So if you can limit it to that, I will allow the proffer.
Also, and we can ask Mr. Connor to testify, I do think his qualifications.
The judge is correct, and she's trying to tell Don West, who has a problem listening to the judge. I don't know if he listens to any judge, or if it's just Judge Nelson, but he just, when the judge says something, most attorneys get what the judge is hinting or saying and whatever. And the judge is saying, look, I don't want to go through a long, drawn-out hearing. Just tell me, if you want to put this guy on the stand, just have him tell me how he went about finding this stuff and what he found. And that's it. So it sounds like Don's getting ready to say, well, no, I want to talk about all this other stuff too. So let's find out what he has to say.
I have him here in the CV. For the purpose of the proffer right now, I don't. You said he got them from a place that was a second-level access. If you would like this court to understand what he means by that, I'm happy to hear that proffer. For the purposes of this proffer, I really don't need to go into his qualifications. I have his CV here. It's 00. I can read it.
Yes, ma'am.
So
the other issue I'd like to point out to the court before we do the proffer is that Mr. Guy's argument completely misses the point as to why this information is admissible. This isn't reputation evidence under Munoz. This is evidence that directly relates to the physical abilities and capabilities of the individuals at issue. That's a jury instruction that the court will give. That directly relates to Mr. Martin's knowledge of fighting, that he had participated in a fight, that he knew, in fact, what it was like to be on the bottom.
well, Mr. Connor is not going to testify as to what was intended by this. Is he just where he found it and that he found it?
I'm suggesting that Mr. Guy's argument was misleading as to why it's admissible and the significance of it legally. So I don't want the court to think that I'm not responding to the argument because it wasn't the right one.
I'm really at the point where I want to hear the limited proffer from Mr. Connor. I'm not at the point to hear the
Now, Mr. West, concerns are really extremely properly valid. I don't know why I said all those words. He doesn't want the court, because some judges will say, well, you didn't address Mr. Guy's or opposing counsel's argument, so I'm assuming that you agreed with him. So in abundance of caution, Don West is saying, well, no, wait a minute, Your Honor, I want to respond to what his arguments were, lest the court think that I don't have a response or that he's right, that Mr. Guy is right.
arguments. I understand that Mr. Guy gave an argument, but I told you I'd like to hear the limited proffer. So if we could get Mr. Connor in here, we can do that and take it a step at a time.
This is a deposit exhibit that relates to the gun matters. I'll mark that as well.
All right, that will be double P.
Please only swear from the testimony presented will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
for the purposes of my client.
There's another exhibit, a composite exhibit, that I'll ask Mr. Connor to speak with briefly as well. It contained some photographs that were found on the phone.
Notice how many minutes we've taken, and the witness is finally on the stand, and we still haven't got started.
No.
And that's what tries everyone's patience.
That's double Q.
Let's get this thing going.
Good evening.
Good evening.
Please state your name for the record and spell your last name.
Richard Donald Connor, Jr., C-O-N-N-O-R.
Mr. Sorry, thank you. Mr. Connor, prior to you taking the stand, we marked a copy of your CV, and it's been admitted into evidence. Is that correct, Your Honor?
It has not.
Would I so move?
Well, this is a proffer, so if Mr. Connor were going to be testifying in front of the jury, you can move it in at that time.
In order to save time, I would like it admitted into evidence so the court can review it and consider part of his testimony today.
Now notice how we're going to take 2 minutes just dealing with the guy's CV, which is like his resume, qualifications. We're going to spend 2 minutes just discussing whether or not this should come into evidence or not. And this is why the judge, everybody gets upset. Don West gets upset, the judge gets upset because of tedium like this. Tedium, I'm kind of slurring my words here.
Unless there's an objection from the state, I'll review it as a composite, but because when something is marked as evidence, it goes back to the jury. The court hasn't made a determination yet as to whether or not Mr. Connor is going to testify, so I don't want that as an exhibit going back to the jury.
I didn't mean to suggest that it would be admitted into evidence for the jury. It would be admitted into evidence for this proffer.
Well, then it wouldn't be marked as double N. It would be marked as one for this hearing. So do you have another copy, or do you want me to take that double N?
I have another copy. I was suggesting perhaps that since the jury doesn't get things that are only marked for identification, if the court...
I just can't believe we're going around and around like this.
Well, I'll have to remark that one unless you have another one that you would like to provide. Either way, doesn't matter.
I can retrieve that one, so I have one and substitute another.
Well, the court can just mark that as Defense Exhibit 1 for this proffer. I just wanted to know if that's what you wanted.
Yeah, let's just talk about it for 2 minutes.
So, Mr. Connor, does your CV that's now in evidence for this proffer as Defendant 1 generally describe your background and training in the area of computer forensics?
Yes.
In addition to the training specifically as a computer examiner and in forensic computer analysis, are you also a licensed attorney in the state of Florida?
Yes, I'm a member of the Florida Bar.
Have you testified as an expert in the area of computer forensics to include extraction and analysis of information from cell phones in the past?
Yes.
Are some of those instances set out in your CV?
Yes.
Are you certified by Cellbrite?
Yes, I went through their training. At the end of the training was certified in logical and physical.
Are you generally familiar with whatever the most recent software program is for cell phone analysis?
Yes.
And do you have a licensed copy of the current version that's available to the private sector?
Yes.
And did you use that software in whole or in part to analyze the phone that was represented to be Trayvon Martin's?
Yes.
At some point in the discovery process in this case, did you receive what's been known as a bin file?
There were several bin files, yes.
Was there a bin file that you received sometime in perhaps late February or early March that was represented to be, in effect, the data dump from the flash memory of Trayvon Martin's phone?
Yes, I believe it was February 23rd.
And did you have an opportunity to use your Cellbrite software and other software that may be available to you to begin the process?
Notice that the media has dropped off. There's 1, 2, 3, 4, 5. I don't know if the person on the far right is media, so that's 1, 2, 3, 4, 5. About six people left.
Process of analyzing the data on Mr. Martin's phone.
Yes.
Were you able to identify text messages, Facebook posts, and such that had been deleted or otherwise hidden from a cursory examination of the phone?
Yes.
Would you describe generally what your process was insofar as the use of the Cellbrite technology?
Well, when you load the data into the Cellbrite physical analyzer software, it runs a series of scripts basically and analyzes and then parses out the data. For example, the names in the contact list, the calls in the phone call log, text messages, emails, the pictures, videos, songs and music, things of that nature. It parses them out. I think it's called the analyzed data section of the report.
Okay. Did you, when you began this process, did you have an opportunity to look at the report, the printout, if you will, that FDLE had done in connection with this phone?
Yes.
And when you did your own analysis, did it indicate to you there may be additional information on the phone that had not been provided in report form by the State Attorney's Office?
Yes.
And what did you do then with the bin file, if you will, and your other resources to try to capture or identify what information that was missing from the State Attorney's report?
Well, the report is only a report of what the Cellbrite reads and interprets and parses. The bin files is more like a physical image of the phone's data, so it contains all the data, all the files, all the free space and everything. So when I have the bin files and I've loaded it into the Cellbrite Physical Analyzer software, I can then examine any file that's from the phone, whether or not Cellbrite was able to parse it or analyze it.
Now, what's important here is that just like the DNA was discussed and each side had their experts discussing the DNA results and blood results, etc. And remember that the experts, DeMaio and who else, discussed the contamination of the clothing, and that would affect the lab work testing done on the jacket, Trayvon Martin's hoodie, and the t-shirt. So here this expert's going to be discussing the cell phone data, and he needs to discuss how nobody else had access to his software, the cell phone, the data, etc., that nobody went in there and tried to fool with the evidence, doctor it, whatever. So his discussion right here about his methodology, so to speak, is important.
Was there something that struck you when you began the process of analyzing the bin file and comparing it with the report that the State Attorney's Office had provided?
Yes, one of the first things that I did was in the Cellbrite report that I received from the State Attorney's Office, for each section of the report, it lists how many items are there, how many pictures, how many videos, how many text messages, things like that. And so I looked, when I loaded it into my Cellbrite, at the total numbers to see if they matched, and I noticed that one in particular, the picture number was off by about 600 pictures. I had 600 more than the FDLE report did.
Did that make you think there may be some additional information on the phone that was not part of the report?
Yes.
And what did you do in order to try to find those pictures?
I tried to figure out which pictures were different and whether they were all located in the same area or areas.
We're talking about comparing this FDLE report with what your preliminary indications were from your own software run, the Cellbrite.
Correct.
When you got the bin file in late February, did it include an updated report from the one that had been previously provided in discovery without the bin file?
At some point, there was a second report, yes. It was somewhere around late February, early March, I believe.
Was it substantially different than the first one in that it contained did it contain any of those 600 photos, for example?
No.
At some point, did you later get an FDLE report that appeared to have some of the additional data that you were later able to find?
Yes.
And when was that?
I believe it was the week before this trial started, first week of June, I think.
That was the next time that report was, that was the next updated report.
Yes.
So let's talk about what you did then in order to try to identify the data that was on the phone but not part of the report that the state provided. So were you able to extract additional information by your own application or use of the Cellbrite software?
Are we talking in general or still talking about pictures? Or?
Identify it however you choose. Once you realized there's more data on this phone than what was in the report, what did you do to try to find it?
I did a couple things. In terms of text, I started running some keyword searches, physical keyword searches against the bin files. I also, one of the things I do is I look through, the Cellbrite report did list the databases on the phone, and I started looking through the databases to see what program or app they belong to, what they did, and what they contained. So those are the two main things that I did.
Were you able to identify some additional photos that were not part of the report?
Yes.
Did those photos include pictures of a handgun?
Yes.
did those pictures include a hand wrapped around the grip of the handgun?
Yes.
And when you analyzed that, were you able to determine that the pictures of the hand on the handgun were taken by that phone?
Yes.
Were they?
Yes, they were.
Do you have... I'm sorry. This is more than just pictures. If you would take a look at it, though, and generally describe what that exhibit consists of.
Including the text?
Yes.
There are several text message exchanges where Mr. Martin was either trying to purchase or sell a handgun. And then there are there's actually two copies of the two separate pictures, one of the handgun on a table or something, and the other one where it's lifted off the table is in somebody's hand.
You were able to find those text messages on the phone?
Yes, they're on the phone.
And were some of them deleted?
Yes, they were, yes.
Is your software able to recover deleted text messages?
Well, they were marked as deleted, but they were still, the data was still on the phone. So each picture had a deleted version, although the data had not been overwritten, so it was still there. And there was another version that was still on the phone intact.
When someone who has a picture on the phone or a text message they don't want and they want to delete it, is that a purposeful action taken by the user of the phone?
Same.
Is this something that happens by accident or as a result of the phone itself, or to delete the images and text messages, or does that require the operator phone to do something?
Usually, yes.
Explain, if you would.
Normally, pictures, for example, will stay on the device until they're deleted or removed. Text messages, depends on the phone, but will often stay on the device until deleted or removed. That being said, devices go bad, memory cards go bad, and it technically it's possible for something to get deleted without the user intending to delete it. So that's why I said it's usually user initiated.
If you were trying to determine as an expert whether this was an action by the user or a malfunction of the phone or something, would you be able to look at the text messages that were deleted within the context of others that weren't?
Yes.
And were some of these text messages deleted and scattered within other text messages that weren't?
That is correct.
As an expert, is it your opinion that these deleted messages were because of an act of the person on the phone? May I?
Like anybody. That is speculation.
Anybody, yes, perhaps, but...
But you're asking him to speculate.
No, I'm not asking him who did it yet. I'm asking him whether the text messages were deleted because of an action someone took.
Okay, well, that question would be allowed.
Yes.
Yes.
Is it your opinion that the text messages relating to the gun that show deleted were deleted by someone on purpose?
Yes.
You know, if you listen to the judge, some people criticize the judge and say she doesn't know what she's talking about. I think it's probably an 80-20 split. 80% of the time she knows what she's doing and knows full well what's going on. She has shown herself to be extremely diligent and at full attention as to what's going on in the case. But sometimes she gets it wrong, like this authentication issue towards the end. Like this exchange right here, she was right. The objection was speculation, as the question was asked. But then she said, "Well, if you rephrase it, it would be allowed." And so West took the hint, which wasn't really a hint; it was a question. That, well, does it indicate that the data was deleted by somebody? Yes, it was. It was put into a deleted folder because when somebody tries to delete it, it goes into this space on the phone.
Were you able to determine if the phone had a passcode or swipe code of some kind?
Yes.
Did it?
Yes.
What does that mean?
That means that you cannot access the data on the phone unless you input the passcode.
If you don't know the passcode, can you operate the phone?
Perhaps maybe an emergency call, but other than that, no.
Do passcodes typically time out? So that if you access a code, access the phone, over a period of time, is there something in the phone that will cause it to become secure so that the passcode has to be re-entered?
Yes, for example, you may have to wait 10 minutes to try again to get in, and that time may increase each time you put in a wrong passcode.
Let's talk.
Okay, now this is important because this is where I think the judge got it wrong. At the end of the hearing, which you will hear, she says, I don't know if an 8-year-old had access to this phone and she or he, whatever, was the one sending all these text messages. Well, if that was the standard of proof on admissibility, meaning that this cell phone data could come in if you show it hasn't been hacked or cracked, then nothing would ever come in, because there's always a possibility that someone, somewhere, unknown to anyone, had access to the phone. In a sense, it's the judge requiring West prove a negative, meaning that he has to prove something didn't happen in order for the phone data to be admissible. That's clearly wrong. It's similar to if you were flying on an airplane. You trust that when you get on an airplane, it's going to take off, it's going to land, nothing's going to happen, it's not going to crash. If I went up to you just before you were going to board the plane and said, well, are you certain this plane is not going to crash? You would say, well, no, I can't say to a 100% certainty the plane's not going to crash, but I trust that it won't. And then if somebody says, well, I want you to prove why this plane didn't crash when you land, and it was a safe journey, somebody comes up, and that same person, let's say, and says, well, the plane didn't crash, and how come it didn't? And prove that it did not. You can't do that. You can't prove a negative that as to, well, I don't know why it didn't crash. It just didn't. So here we have the same thing, and maybe that was a bad analogy, but with this phone data, the judge can't really require that for the phone data to be admissible, that Mom West have to go out and prove that it wasn't hacked into. And this expert is the reason why it should be admissible, at least on authentication grounds, because he's going over, well, there's these like 8 layers of security for this data that I found. That means the odds of somebody other than Trayvon Martin penetrating those 8 layers of security, starting with this phone passcode that we can set our phone to log into your phone, you have to enter the passcode. Starting with that, for somebody to penetrate 8 layers of security is impossible. I mean, it just doesn't happen. And remember, his phone was found at the scene, it was bagged, and it's been maintained secure ever since then. So we saw Trayvon using that phone in the 7-Eleven, and we also heard Dee Dee say he was on the phone, on his phone. So we know that that phone, as found, was intact and secure. So that's why the judge is off on this. But listen to how this expert describes all the different layers of security and precautions that Trayvon Martin took so that nobody could read his text, see his pictures, and whatnot.
About what happens if you put in the right passcode and you get access to the phone. If you put the phone down and don't use it for a period of time, the phones typically have a default where they go back to the point that after several minutes or what have you, you have to re-enter the passcode.
It did have a default timeout period.
One would suggest, I take it, that if it didn't have some sort of timeout, that you'd only have to enter the passcode once and it would remain open forever, essentially.
Until manually locked or restarted.
Which would sort of defeat the purpose of the passcode.
Is there anything else that I can...
Well, are there identifiers on these text messages, who sent them, and whether or not it was sent to Trayvon Martin or by Trayvon Martin?
Yes, the messages will state which folder they are in on the phone, for example, an inbox or a sent folder, who the other party is, whether the message is incoming or outgoing, the date and time of the message, the status of the message, whether it was read or sent, for example, the content of the message, and then the status of the message, whether it was deleted or whether it's not been deleted.
Is all of that indicated on the extraction reports you have there?
Yes.
Was there a conversation between Trayvon Martin's phone and a person identified by name and number as Ron Cuevas Fulton about purchasing a .22 revolver?
Yes.
Were these conversations concerning the acquisition of a firearm clustered in date?
Yes.
When was that, please?
Yeah, just the ones with Qua Fulton, or all the ones that we have here?
All of the ones that you have regarding what seems to be the acquisition of a firearm.
Between February 18th of 2012 and February 22nd, 2012.
And how many separate collections of text messages do you have there on that?
Several. There's 1, 2, 3, 4. I think there's at least 4.
With different people?
Yes.
Can you identify who those people are from the information on the phone?
Yes.
Who are they, please?
One is Qua Fulton. That's one. There's another group that there's two other people involved in addition to Mr. Martin. I think they run together as one kind of conversation. That's the other parties are Spoonhead Zach and Jay. And then there's another set of conversations that with another person named Ron. There's conversations with a person named Dario, and another conversations not about purchasing but about a gun with Diamond. And I think that's it.
Did you...
Fruit. I don't think I mentioned fruit.
Fruit.
Conversation with fruit also.
This collection of conversations were all between February 18th, 2012 and February 22nd, 2012?
Yes.
Were there some text messages on the phone where Trayvon Martin was talking about coming to Sanford?
Yes.
Are you generally familiar as when he was planning to come to Sanford from reviewing those text messages?
Yes.
Tell us, please.
I believe it was February 20th to 21st, around that.
And you know enough about this case that he was killed on February 26th.
Correct.
Let me show you another exhibit. This one is marked Defendant's QQ for the proffer. Let me ask you if this is based upon information you received from the phone.
Yes, it is.
What is it?
This is a picture that appears to be of Trayvon Martin that was resided on his cell phone.
Does it appear to be a self-taken picture?
Yes, it does appear to be that.
Was that picture taken with that same phone that you analyzed?
That I'm not sure. There's no metadata in the image that identifies the device the picture was taken with.
What is metadata?
The best description I've heard is it's data about data. So, for example, in a picture, very often if you take a picture with pretty much any digital camera or cell phone these days, within the picture file itself will be data about the picture, the make and model of the phone or camera, maybe the focal length, the date and time, maybe GPS coordinates, all kinds of data about the picture itself. That's metadata.
Are you able from that metadata to learn more about the circumstances and the device that where the picture was taken?
When it exists, yes, it often provides additional detail for us.
You said this photo appears to be Trayvon Martin. Is that based upon other photos that you know exist that depict Trayvon Martin that you've seen either on the phone or online or on TV?
Yes.
Were you also able to extract a series of text messages and other postings that appeared to relate to Mr. Martin having been in at least one fight?
Yes.
Let's talk about how you were able to recover the data on the phone that related to that extraction.
There was data on a phone in a database that was not parsed or analyzed by the Cellbrite software. And so when I went and manually looked at the database, I saw that it contained what appeared to be text messages. And then when I looked at the database and the configuration file associated with the database, the database appeared to be created by an Android app called Super Android SPC, I think. And when I researched that, I saw that it was an application that was designed in part to hide text messages. And basically what it did was text messages that were subject to this application were...
Okay, here's another layer of security that I mentioned before. Remember, he said that the phone has the passcode that we all have on our phones, but this is an application that Trayvon Martin or somebody, or an 8-year-old, according to the judge, downloaded and installed on his phone, and this the expert will now explain what this program did.
Not put into the main text message database that you think of when you look at an Android phone. It was placed into another database that was only accessible to the Super Android application. So for that reason, I believe it was not parsed or analyzed by Cellbrite, but when I went and looked at it, I could see the data was there, it was in plain text, and I could extract it and analyze it.
How did that get your attention? What made you think there's more here even than what running Cellbrite had revealed to you about the missing pictures and such?
There were a couple things, and I don't remember the exact order or which one was the final tipping point, but one of the things I was doing was running keyword searches, and I was getting hits of what looked like text messages, but they were not in the parsed text messages in the Cellbrite report. That was one indication. Another indication was the SBC database was listed in the databases, but there was no parsed data from it in the report. And then I'm missing this one other indication. But I think those were the two primary ones, the search results, and then when I eventually got to look at it, I could see that it contained what appeared to be text messages.
Is that something that you were piecing together, realizing that there was more on the phone than what was indicated in the report from FDLE that provided by the State Attorney's Office?
Yes, and I think you need to keep in mind when I originally got this data, there were certain things I had been asked to look at, so there were other things that I noticed that I was kind of noting in my mind and putting on the back burner until I got to them, and this was one of them. And
thinking that there might be something else going on, you mentioned a hidden app. Were you generally familiar with the existence of those sorts of things?
yes, I knew that those type of apps existed.
And what did you do in order to find the hidden app on this phone and then get access to the information that had been previously hidden?
Probably ought to describe what I mean by hidden. When we're using the term hidden, it's hidden from the user of the phone, unless you know the app and the code. So if you wanted to see these hidden text messages, if you were holding the phone in your hand, you would have to pull up the app and it had a passcode. And you have to put in the passcode and then you could view these text messages. So they're hidden from the user of the phone unless you know how to get to them. Once I get the phone, they're not exactly hidden. They're not parsed by Cellbrite, but they're not hidden either. Once I locate the database and I access the database and view the database, I can see the data in plain text. So it's not parsed by Cellbrite, but then again, it's not hidden by the application from me either.
Are you saying that there is a passcode necessary to unlock the phone so the phone can be used, and then a second passcode that would have to be entered into this application to access these text messages?
That is correct.
So in order to get access to the text messages, arguably you'd have to know both passcodes.
Sustained.
May I have a little leeway with an expert to lead so we just stay on track? I will rephrase it though. How many passcodes would it take to get access to these hidden text messages if someone handed you the phone?
At least two.
Would that be the access code necessary to open the phone up for any purpose?
Yes, if the phone was locked, you'd have to put in the passcode to unlock the phone. Then you'd have to locate the app that was hiding the text messages and put in the password for that app. And then you would get access to the text messages.
If you were unfamiliar with the phone, how would you know what app that was?
You would not know. You'd have to try to find it, maybe see if you got lucky finding the app, and then you'd still have to enter the password.
So for someone else to use the phone, they would have to figure out the first passcode in some way.
The phone
Okay, now pay attention to this. This is meant for the judge. It's exactly what Don West said at the beginning. He wanted to show that there wasn't an issue with authentication, meaning that this was Trayvon Martin's phone, this was his data, these were his texts that he was sending, etc. So Don West is painfully, meticulously going over this, and arguably he had reason to be upset when at the end the judge said, well, I have a problem with authentication, and how do we know that somebody else didn't access this phone and send these texts?
passcode, yes.
And then they would have to figure out that there was another hidden app on the phone that had text messages.
Correct.
And then figure out what the passcode was to access that application.
Yes.
And then at that point, would they be able to send and receive texts?
Yes, they would be able to see the texts that were being hidden by that application and probably respond to those text messages.
Well, I suppose if someone had gotten through those levels of security, they could, you said they could respond to the messages or delete messages or something. But
Yes, they would basically have the access that the user who set up the application password would have.
when you were looking at the context of the text messages, in the regular texting and also in these hidden files, did you consider whether it appeared that someone else was using this phone to send text messages and delete messages other than Trayvon Martin?
That's always something that we look for and keep in the back of our mind. At least I do. So yes, that is something that I took into consideration as I was examining the data.
Were the text messages that you've extracted relating to the gun and fighting, which we will talk about, contained within a larger conversation with the same person typically?
Yes.
And did those conversations appear to indicate a relationship between that person and Trayvon Martin?
Yes.
I'm losing track of my thinking here, but were you able to collect the various text messages from whatever source related to firearms and assemble them in the exhibit before you?
Yes, that is what I did.
Let's move to another exhibit. This one's been marked for identification in this proffer as NN. If I could approach the witness.
Everybody's tired.
Are you familiar with that exhibit?
Yes.
And what is it, basically?
It's a composite of data relating to fights or fighting.
Did all of that data come from Trayvon Martin's phone?
Yes.
And did you extract it in some fashion or another?
Yes.
You mentioned earlier that there was a database that was accessible through the hidden app as opposed to through Cellbrite.
Again, there's accessing it by the user or accessing it by me. If the user is trying to access the data, they have to go through the special app and the special password. Cellbrite, from my point of view, Cellbrite does not parse or analyze the data, but it is there, and I can manually access it and view it using the Cellbrite software.
Looking at the first page of Exhibit NN, I think is the one before you.
Yes.
The header at the top has an identifier as spc.db log sorted by person.xlsx. Could you explain that, please?
Yes, I created this spreadsheet, and it comes off of the phone, and the database is the spc.db database. That's what it's named on the phone. A database, in this case, it's a SQLite database, and a database consists of several tables. So, for example, in this is the log table as named by the application, and it's a log of the text messages. There are several other tables. One, for example, maybe the contact or name table. It'll have the names of the persons that he was texting with or in the address book, their phone number, etc. So, and this is presented to me in the Cellbrite software in a table, and I can then use the Cellbrite software to export it basically into a spreadsheet, which is what I did. And my software named it by beginning with the name of the database on the phone, spc.db, the table in the database, this is the log table, and then appending the Excel extension to the name of the file.
From a longer conversation in this thread with the person Lavandria, were you able to extract a conversation relating to a fight?
Yes, there were other messages going back and forth between Mr. Martin and Lavandria, and I extracted these specifically because they did relate to a fight.
And does your spreadsheet show the phone number of Lavandria?
Yes.
And you know this to be from Trayvon Martin's phone?
Yes.
And are you able to tell from the spreadsheet and your analysis which of the two sent and which of the two received the messages?
Yes.
Are you also able to identify the date and time that these messages were sent?
Yes.
What is the first line in your exhibit of text?
The number or the content?
I have a larger extraction here. So what's the first line of text on your exhibit?
WID question mark, which is what you're doing.
You recognize that to be text code or slang for what you're doing?
Yes.
And who sent that?
Lavandria sent that.
And did Trayvon Martin respond?
Yes.
What did he say?
Tired and sore.
Did Lavandria respond to that?
Yes.
What did she say?
Me too, but what happened?
I'll slow this down to regular
I'm gonna ask
speed.
Mr. Connor, that you do the best you can to pronounce the way it's actually written.
That's what you need to do.
Okay. So Lavandria said, me too, but what happened to you? What did Trayvon Martin say?
What I mean is I'll put this at regular speed because I think it's important to hear these texts.
Fight.
And what did Lavandria say after that?
Fight, exclamation, question mark.
And what did Trayvon Martin say to her?
That nigga snitched on me.
And what did she say to him?
They, why you always fighting? Man, you got suspended.
And what did Trayvon Martin say in response?
Nah, we thumped after school in a ducked-off spot.
What did Lavandria say?
Oh, well, damn me.
And what did Trayvon Martin say in response to Lavandria?
I lost the first round, and it's got the kind of the happy face, I guess, the colon and the parentheses. But I won the second and third.
And then did he repeat that with a different smiley face, the frown as opposed to the smile?
Yeah, it's basically the same, but it's I lost the first, but won the second and third.
And did Lavandria respond?
Yes. Oh, so it was 3 rounds with a question mark. Dammy, well, at least you won, LOL, but you need a Actually, there's another couple words on that.
Can you read that whole line?
Yes.
I can show you my copy.
I've got a copy also.
Okay.
But you need to stop fighting, Bay, for real.
And did Trayvon Martin respond to Lavandria?
Yes.
What did he say?
No, I'm not done with fool. He gonna have to see me again.
Did Lavandria respond?
Yes.
And what did she say?
No, Bay, stop. You ain't gonna be satisfied till you get suspended again, huh? With the question mark.
And what did Trayvon Martin say?
No, but he ain't breed enough for me. Only his nose. But after that, I'm done.
The text that you read said breed.
Yes.
Okay, this is somewhat hilarious because it's obviously a typo. Breed, he meant bleed. But I think John Guy objects to the expert saying, well, he meant bleed. He said objection, speculation. So everybody's going around and around on what word Trayvon Martin intended to type. It's like common sense. The jury can figure that out. If they want to think he was talking about breeding with an R, fine. If they use common sense and know he meant bleeding with an L, that's fine too. But anyway, listen to this exchange.
But he ain't breed enough for me.
If that were a typo and it were an L instead, how would it?
Objection, speculation. If
I have to sustain this as speculation.
West is thinking, what the
Have
hell?
you seen typos before in text messages that you reviewed as part of your phone analysis?
My analysis in reading this is that the word breed does not make sense and is not what was intended.
What would make sense?
Bleed,
With an L, bleed.
with an L, bleed.
Judge, I'll renew my remark for my objection as to speculation. That's for that
Sustained.
remark. Has to be stricken.
Your Honor, I would not want the record stricken. This is a Crawford.
Donna West. I just have to laugh even at this late hour. I have been at this, let's see, 5 in the morning. It's 11:30 here in San Francisco, so that's how many hours? Wow, it's going to be 18 hours. All right, and anyway, I just have to laugh at this because the look on Don West's face, he's going, what the hell? Actually, he's going, what the fuck? But anyway, I think it's just so funny. And look at the media, and look at everybody. I mean, everyone is just exhausted, and they got to be back in the morning.
This is, unless the court hasn't ruled. Did the court rule on Mr.
Ruled on
Van?
his objection to speculation. It is what it is. What's written there is written there. What the person intended or not, he cannot testify to. What he believes may make sense may not make sense to the author of it. So that's just speculation on his part. My ruling stands.
Have you, in your training and experience and work analyzing phones, computers and phones, have you had occasion to try to make sense out of text messages or computer messages that weren't grammatically or accurate from a spelling standpoint?
Objection relevant.
Overruled as to relevance.
Yes.
In the context of this text message sequence, as you try to sort out the data on the phone and make sense of the conversation, does the word breed as opposed to bleed make sense?
I think when you put it in the context of the rest of that message, referring to not enough and only his nose, yes, I think they're talking about bleeding from the nose.
Thank you. If you would,
To speculation.
Another point on this. This is a proffer. The only people present are the person on the stand, the expert, the questioning attorney, Don West, and the judge. Regular objections, so to speak, don't matter, such as speculation. This is a judge. Everybody knows what each person is saying, and that kind of objection doesn't really matter, because of what they're attempting to do with this expert and the evidence. Speculation doesn't really fit into the overall scheme of things. And this person is or can testify on those matters. The expert can give an opinion as to what someone meant in their text message.
Were you able to, by analyzing the data on Mr. Martin's phone, find another conversation around that time that seemed to reference that fight?
Yes.
And to whom was that text message?
Michael Suave French.
And do you know that person from information on the phone?
Okay, I'm going to
Did you
speed
have
it up
his
now.
Contact information and other conversations between Mr. French and Mr. Martin?
Yes.
And what is the conversation that Mr. French and Mr. Martin had connected with this fight?
Mr. Martin sent a message to Mr. French stating, yeah, because he got more hits in, because he got more hits because in the first round he had me on the ground and I couldn't do nothing. And then Mr. French responded, dang, bro.
Is that the end of that sequence?
Yes.
Did you also find a reference to fighting by a relative of Trayvon Martin?
Yes.
Who was that person?
Demetrius Martin.
And what did where was that information?
It was on the phone. It was in a Facebook database. I believe the name of the database is fb.facebook.db. Inside the database, as in the other SBC database, there are different tables. One of the tables in this database is called mailbox threads. And this particular message was in the mailbox threads table of the Facebook database on the phone.
And what did the message on this mailbox, Facebook mailbox thread say?
It was from Demetrius Martin, and it said, when are you going to teach me how to fight?
Do you know from other information Demetrius Martin's relationship to Trayvon Martin?
I believe there's some kind of brother, half-brother related with the same, sharing the same father.
What makes you think that?
Because there's one other message in the Facebook database in the mailbox thread table from Demetrius to Trayvon, asking Trayvon if Dad had a Facebook page.
You believe, based upon the context of these conversations, that Demetrius Martin was talking to Trayvon Martin about their common parent?
Yes.
Were there other references to fighting or questions? Were there other discussions in the context of your review of the text messages where people discussed fighting to some degree?
Yes.
You didn't extract those for this exhibit because you couldn't find them directly related to this event? Is it, or?
Correct. Or because I could not put it in date, time, or who sent them, yes.
Your Honor, I would move the marked exhibits into evidence for the purpose of the proffer, please.
We'll have to take them out of where they've been marked in the case. So NN will now come in as defendants 2. PP will come in as defendants 3, and PP will come in as defendants 4. This copy.
In summary, Mr. Connor, sort of identifying the different places on the phone where you found information to direct the court as to what the overall scope of your work was that's reflected in some of these reports. There was some information in the report that FBLE filed initially that you were able to verify within the bin file?
Yes.
And then there was additional information in the bin file that you were later able to extract that was not contained in any FBLE report that you received prior to about June 4th.
Correct.
And there was information in this bin file that you were able to extract from applications that were hidden on the phone?
The jury's not here, it's fine, go ahead.
Is that accurate?
Yes.
And to do that, to get the access to the hidden application, you had to download some software, figure out what it was all about, and review what was otherwise not visible on the Cellbrite reports?
No, no, it was not parsed or analyzed by Cellbrite. So I had to manually identify that it was on the phone and then manually go access the file or the data and look at it. The Cellbrite did not present it for me. I had to manually go find it and look at it and analyze it.
And some of that report is reflected in some of the pages of the exhibits before you?
Correct.
As well as some information that may have been extracted through the Cellbrite software itself?
Correct.
And then photographs that you were able to extract from the bin files?
Yes.
That would include the picture of Mr. Martin, the sort of profile picture?
Yes.
And the pictures of the handgun with the hand that we talked about?
Yes.
I don't remember if I asked you this. Were the pictures of the handgun with the hand taken by Mr. Martin's phone?
Yes, they were taken by the phone.
Officer, when did you notify defense counsel that you had found some additional information that you didn't believe anybody else had found, or at least anybody else had reported?
I'm sure. No.
Were there images of pornography on the phone?
Yes.
That were not deleted?
Yes.
Well beyond the scope of the
Your Honor, this directly relates to Mr. Mantai's claim that someone else could have deleted these text messages. I submit that if some family member got a hold of this phone, they wouldn't have gotten rid of the talk about fighting and guns and left all the pornography on it. I think that the court needs to know what else was on the phone that rebuts what Mr. Mantai is suggesting.
Again, that has nothing to do with the scope of proffer, which was only listed in this exhibit.
Okay, it has nothing to do with the scope of the proffer. I understand your point. Go ahead.
Could you explain that, please?
Well, yes, there are the pictures of the gun.
Okay, this is an additional layer of security that I had mentioned before. Remember, we have the passcode to get into the phone. Then you have the app that hides this text and pictures. That the name of the app is disguised, if not made invisible. Then you have the files themselves where the name is changed, and you have to know that the file name, for example, a JPEG had been changed to a bin extension. That's another layer of security. So anyway, just listen to the expert reveal all these things that should have told the judge nobody messed with his phone, and nobody changed the evidence. Nobody tried to frame Trayvon. Nobody else was using his phone to send text messages and keep porn anywhere within the phone, etc.
Were hidden also on the phone, and by a separate application that was on there. And what this application did not put them on the SIM card where pictures normally go, but it created a...
I think he did not mean the SIM card. I think there's a way to save text messages onto a SIM card if you want. It saves, but only the subject line, something like that, of emails or phone numbers, and very little text information. I think maybe text phone numbers is all it will save. I think he meant to say that the micro SD card, the chip that you can put into your phone that ranges from 4 GB up to 32, 64 GB. I think that's what he meant.
A folder, basically in a program file with a French language name, so it looked like it was a French language folder. And it put the pictures in that folder, and it also renamed the extension. The pictures taken with the camera are JPEG pictures, and they have a JPEG, JPG extension. What this app did was it also changed the extension of the pictures from JPEG to .bin. So in normal computer and digital data use, if, for example, you go to click on a bin file, your app's going to tell you, I don't know what this is, I can't open it. Whereas if you double click on a JPEG, it'll open up as a picture. So this app moved them and hid them, and again was password protected. And these were pictures that were not deleted off the phone. Whoever was using the phone would have to, again, have the codes to get to those items and know where they were.
Are you saying it's a separate hidden application from the one for the text messages?
Yes.
So there were two hidden applications that required a separate access?
Yes.
And the text messages were in one of them, and the pictures of the gun, among others, were in another.
Yes.
And that, if I hear what you're saying, the casual user of that phone wouldn't see those pictures unless they knew how to access that application.
Exactly.
And the application assigned a different file name so it would not appear to be a picture.
Correct. If you were just browsing the content of the phone, let's say you had an app so you could browse the folders and files, you would see these as bin files and not as picture files.
Thank you.
Thank you. May Mr. Connor be excused? Can I have these, please?
You may.
Thank you.
Now, it's getting towards the 10 o'clock hour in the evening. Again, everybody has been here in Florida time since 8:30 in the morning, meaning they had to get up earlier. So everybody probably got up about 6 o'clock in the morning. Lawyers tend to get up way earlier than that when they have trial. And everybody's pretty much had it. So everybody's tense. And the judge, when the judge said, "May Mr. Connor be excused," she was saying, "Mr. Connor is being excused, no more questions." She doesn't want any of this direct, redirect, cross, recross, cross, etc., that the lawyers have done oftentimes. And I submit this witness probably wants to leave too. He wasn't planning on being here at 10 at night, even though he's probably making $500 an hour.
May Mr. Connor be excused?
Yes, Your Honor.
Thank you very much, sir. You may be excused. Okay, the testimony's been proffered. I'll hear argument.
There's additional evidence offered.
Okay, let's speed it up.
As the court is aware, Rachel Jeantel has been a witness in this trial, and that she also was deposed. She was deposed over a period of 2 days, a little over a month apart, and of course the state was present. And at her deposition in April of this year, while she had denied that Mr. Martin had talked with her about fighting, that in the deposition in April, she did then acknowledge that she'd had a conversation with Trayvon Martin where he told her that he was in a fight. And in fact, he told her that he knew how to fight and that he was in a fight that he won. We know from her testimony in trial that she'd only renewed her acquaintance with him after a number of years.
Take a look at the judge. I think she has shown amazing patience. She is alert. She has pen in hand. She does take a lot of notes, and she's putting up right now with Don West because the two. It's like what's that saying? Oil and water. I mean, they just don't like each other. So, nevertheless, she's a judge. She's a referee. She's not supposed to be up there taking things personal. So she can't really, especially since a lot of people are commenting on how she doesn't like West, and she's showing it. So now she's trying to appear all judge-like and whatnot. But at the end of a very long day, it doesn't take much for either one of them to have their fuse lit and just have at it, what you will see in short order here.
February 1st. So these conversations about fighting, knowing how to fight, having been in a fight
I'll speed this
that
up.
he won, took place within the, prior to Mr. Martin traveling to Sanford. So that sort of closes the loop, if you will, on this authentication issue that I anticipate the state will argue. So we can offer the pages of the transcript, or the court can accept my proffer of the question.
I'm sorry, I don't understand. Is it your proffer for the purposes of this proffer of Mr. Connor's testimony, or is it another proffer of something you want introduced in the trial, in front of the jury?
Your Honor, the larger issue is whether Mr. Connor will be allowed to testify as to the content of these text messages on Mr. Martin's home. The court has already raised the question of authentication.
I just want what you just told me about the proffer of Ms. Jeantel's deposition. Is it for the purposes of this hearing or for the purposes of the trial? Okay, thank you.
I think Don West is losing it mentally. I mean, he's as you can see, an older man, and I think he's just like anyone, his memory and whatnot start failing, and so you can see Mark Amara trying to kind of help him along, and saying, "Well, your file's over there, and say this and say that." Because West, the guy is razor sharp. He won that expert's motion, the Fry hearing, which I have his closing argument posted. Just a brilliant presentation. And once he gets into mode, I mean, there's no stopping him. He's just excellent. But when it comes to finding papers and keeping things organized, maybe that's just the way he is. He just puts stuff down and then he loses it in the sea of papers you see on the desk, and he just can't find it. But that I admit that happens to me in trial. I've lost track of exhibits. Like I'll grab it from the stack and I'll hand it to the witness and blah 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 blah, and then I put it down and then I can't find it later, because I've misplaced it. Now this is speeded up, so he's actually going a lot slower. There's a little yawn by Mark Amara.
I have an excerpt of the deposition that I can just mark as an exhibit that references what I just orally proffered about that deposition.
I'm not saying an objection, I'd just like to see what you said first to make sure we're in context, please.
And West doesn't like Manatee, the prosecutor there. The guy is just a dodo bird. That's what he is, a dodo bird. That's what he reminds me of. He gets these expressions on his face, and it's just odd. There's something wrong with him. Camera operators getting reckless abandon.
Are we ready for argument?
At this late hour.
Okay, that'll come in for this. Purposes of this hearing is defendant's exhibit number 5.
Number 5 will be the transcript.
Yes.
I did.
I have the other exhibits here. I have, although I haven't been remarked by Lisa, but I'll give them to her in a moment.
Let's move along to
I'm ready for argument.
All right.
If you want to mark these and then give them back to me. Thank you.
Zimmerman saying, "Hey,
Before I forget, Judge, Mr. Zimmerman has a 10 o'clock curfew. May we have it extended until a reasonable time after
Yeah, it'll
court?
be extended for 30 minutes after court is concluded.
Is that enough? Thank you, Judge. Okay. So, on the argument part of this. We are asking that Mr. Connor be allowed to testify as the substance of the text messages that he recovered from Trayvon Martin's phone, specifically as to the fighting. I think that's the core issue here. He laid the predicate for a picture, if it's otherwise relevant and we want to offer it, and for the pictures of the gun and the discussions about the gun. I'm not ready tonight to make the argument why the pictures of the gun and the discussions about the gun
I don't have the pictures of the gun. Defendant's Exhibit number 4 has 3 pictures of the profile of Mr. Martin.
There is an exhibit that was marked that has the discussion of the gun.
Right,
and,
I have that, but I don't have
Now let's spend 2 minutes finding the pictures of the gun.
included in Defendant's Exhibit number 4. The first page is an extraction report with numbers 1, 2, and 3, and then it has 3 pictures of the same.
Speed it up.
The same picture. Those are the only exhibit. I don't have a picture of the gun.
Does the court have the exhibit that has the text messages referencing the gun?
Exhibit number 3 is an extraction report. Oh, yes, here it is. Well, let's see if the pictures are attached. There's an extraction report that has 4 thumbnails. Oh, here they are. They're attached to that.
Yes, okay. And that has the gun and the handle on the gun?
Yes.
Okay. So I don't want to address that specifically tonight. The hour is late, and I'm not suggesting that Mr. Connor can at this come before the jury and testify about the gun and the hand on the gun and the text messages, because I don't think that's been directly related, at least not yet, to the facts of the case. That would go more toward a notion of aggressiveness, maybe even a fact supporting a violent tendency. And
What part of the evidence code are you seeking to have this introduced? This information? All of the information that was proffered by Mr. Connor?
I believe that it most squarely is admissible under, well, no, it's different depending on what parts of the exhibit. The picture of Mr. Martin is simply that he has laid the predicate for a picture of Mr. Martin. That's not related specifically to fighting or guns. It's just a picture of Mr. Martin that was on his phone that shows his physique. That's the relevance of that. The pictures of the gun, the hand on the gun, the discussion of buying a gun and such is not directly related to the fighting issue. The fighting issue, the central core of the presentation, two legal grounds. One is 90.803. That's an exception to the hearsay, prohibition against hearsay that does not require the declarant, that the availability of the declarant is immaterial, and that it relates to an existing mental, emotional, or physical condition. And in that primary text message with Lavandria, Mr. Martin is asked how he's doing, and he says he's tired and sore. And that's because he had just been in a fight that he had won, a fight.
What part, I understand that, but I'm just trying to find out now, what part of the evidence code are you seeking to have that evidence admitted?
90.803.
All of them are 9803?
The text messages regarding fighting, I'm seeking under 90.803, and also under the legal authority of Chambers versus Mississippi, but that's a separate argument. I'm not addressing the admissibility yet of the firearm pictures, because I don't think that we've connected that up completely with the evidence in the, before the jury. So I'd like to concentrate on the evidence of fighting and why that's admissible, and there's several theories. Not as reputation testimony, under UNOs and such, but under 90.803 as reflecting a then existing mental, emotional, or physical condition. And that mental, or emotional, physical condition was at the time that Mr. Martin was in the fight, that he won the fight, and that he explained how he won the fight. He won the fight by, while losing the first round because his opponent was on top of him and rendered him helpless, much like the testimony was that he rendered George Zimmerman helpless in this case.
Okay, can I interrupt you for just a minute? So you're seeking it under 9803 sub 3? Okay, go ahead.
That's one of the legal grounds. That he talks about having been involved in, obviously, an orchestrated fight that was orchestrated for 3 rounds, that he lost the first round because his opponent was able essentially to take him to the ground and make him helpless by being on top. He also talks about how he won the second and third rounds and therefore actually won the fight. He also talked about how he was able to hit the person in the nose and make their nose bleed, but he wasn't satisfied that there was quite enough blood, so he talks about how he's not done yet with this guy. And of course he's cautioned by this person that he should quit doing this stuff. That conversation about that particular orchestrated fight is corroborated by the conversation with Michael French that occurs within a few hours while he talks to Mr. French about this event having gone 3 rounds. So we know those are connected in time and in content, certainly helping toward the authentication that those were the words of Trayvon Martin, the 2 people that he communicated with regularly. Mr. Connor talked about how there were conversations with these folks on other subjects, and that he extracted just that part of it that related to the fights. There's also a Facebook post by Trayvon Martin's younger half-brother, Demetrius Martin, and we can offer evidence in the record to connect up all the dots on that. Mr. Martin has several children. One of them, 2 or 3 years younger than Trayvon Martin, is Demetrius Martin. He identified all of that at his deposition. So we have more of the loop being closed that Demetrius Martin asked Trayvon Martin when he was going to teach him how to fight. Obviously, Demetrius Martin thought that Trayvon Martin knew how to fight enough that he would ask for his advice and training. We also know from the evidence, the proffer of the deposition of Rachel Jeantel, that within the first couple of weeks of February that Trayvon Martin told her that he had been in a fight, that he had in fact won the fight. And we know that from Rachel Jeantel, who obviously knows Trayvon Martin's voice and knows him personally, and testified that it was Trayvon Martin that told her about being in a fight that he had won. All of that is strong circumstantial evidence, if not clear direct evidence, that all of these conversations were by Trayvon Martin, his words being sent to his friends about a fight that he was proud he had won because he was able to draw blood from the man's nose and to ultimately prevail, even though he'd been in a difficult situation in the first round. So factually, we've connected the dots on authenticating this. Why is it relevant before the jury? Because, as the court will instruct the jury, the relative physical abilities and capabilities of the parties is relevant. There's a jury instruction that says just that. And this jury is going to be asked to decide who George Zimmerman was physically, what his physical capabilities were, as well as Trayvon Martin's physical capabilities. And that includes knowledge. That includes experience. That includes Trayvon Martin's experience in fights, having been put in a position of vulnerability by being put on the ground. However...
Okay, listen up. Eventually, I'm not quite sure where, Don West is going to talk about the fact that the state opened the door. He doesn't say open the door, but he does mention that the state put on the physician's assistant Folgate, who said that her notes indicated that George Zimmerman was taking MMA training. And they tried to clarify, well, do you mean aerobics? And she said no, MMA training. And all the implications and innuendo that carried with it.
Of course, in that fight, it was an orchestrated 3-round fight. So when Trayvon Martin lost the first round, when he couldn't get up, whoever was refereeing it stopped it. And then they had 2 more rounds, which Trayvon Martin was able, by hitting this fellow in the face, apparently take steps toward winning. So that shows clear knowledge of Trayvon Martin prior to his contact with George Zimmerman, that he'd been in a fight, that he knew how to fight, and that he in fact knew what George Zimmerman would experience when he was on top of him, because the similar thing had happened to him in the past. We know that this is relevant because the state took great efforts to try to make that information relevant as to George Zimmerman. If the court will recall the testimony of physician's assistant Lynn Folgate, one of the things that the state took great pains to get this court to agree to, and ultimately to question Ms. Folgate on, was when Mr. Zimmerman spoke with her about his exercise regimen, that he had mentioned to her that he exercised aerobically with MMA. And the state made a big deal of that. They made a big deal about it in the case, that he had experience as MMA based upon the medical records from the Altamont family physicians, I guess it is. So we know these things are relevant because the state wants it to be relevant in their case. It's likewise relevant in our case because the jury is going to have to make that decision. So because I think that this information shows the existence of Mr. Martin's mental state shortly after this event occurred, because he's telling the Bondria that he's tired, that he's sore, that he had just been in a fight that he had won, that it is in fact admissible under 90.803.3, the existing mental, emotional, or physical condition at the time of the event. I'm not suggesting that that statement was him talking about anything in February of 2012, but it does in fact, on a relevant matter, show his thinking and his emotional and physical condition at that time. This is clearly compelling evidence in support of Mr. Zimmerman's self-defense claim. The testimony is that Mr. Martin sucker punched him, was able to soon there, by surprise, frankly, and then shortly thereafter was able to get him on the ground where he was mounted. We know from the testimony that mounting is when you straddle somebody around the area of the hips, and that it is an extremely vulnerable position because there are very limited acts that one can do, unless they are very skilled, to get out from under it. You are essentially helpless, and you are subject to the whims of the person on top. We know John Good said he saw Trayvon Martin mounted on George Zimmerman MMA style, and that we know from the physical evidence in the case, all of the physical evidence, frankly, especially the testimony related to firearms, corroborates that the shot was fired from the ground up, that the shirt was separated from the skin by somewhere between 2 and 4 inches, and that it exactly corroborates and is consistent with not just what Mr. Zimmerman said, but with what John Good observed some 10, 15, 20 seconds earlier when he went outside to investigate. So this is absolutely compelling evidence and is highly relevant and admissible under 90.803. We submit that it's also relevant because not to admit it in this case under these circumstances would violate Article 1, Sections 9 and 16 of the Florida Constitution and the 5th, 6th, and 14th Amendments of the United States Constitution that guarantees an accused to confront the witnesses and to present evidence in support of their defense, guarantees due process of law in presenting a defense. This theory, this constitutional principle of, if you will, preservation of the accused rights is discussed in the United States Supreme Court case of Chambers versus Mississippi. The court, I anticipate, is familiar with that decision, but what's to be taken from that decision is that a state's hearsay rules and such cannot be mechanistically applied to deny an accused the right to mount a defense. So I suggest that any application of a rule of exclusion because the court finds it to be hearsay or any other reason would be instead a mechanistic application of that rule that the Constitution of both the United States and Florida prohibits, especially under circumstances where it's clear that the evidence is reliable and trustworthy. We have closed the loop on all of this. It was Trayvon Martin's phone. It was Trayvon Martin's words in the context of all of the other words through the thousands and thousands of text messages that he had with others and with these individuals. He talked about a specific incident where he talked about his skill and the other person's skill in fighting, that he was able to injure the person, but he wasn't done with him yet. Completely consistent with what happened on February 26th when George Zimmerman was screaming for help, but Trayvon Martin wasn't done with him yet and kept on going and kept on going. We have indeed closed the loop the rest of the way with Rachel Jeantel's deposition testimony, that within a couple of weeks of this event occurring, Trayvon Martin had been talking with Rachel Jeantel about winning a fight, being in a fight, knowing how to fight. So this isn't something that the state can say isn't authenticated, isn't reliable, could have been somebody, anybody else just typing this stuff out. That's not at all credible. That can't possibly be the case now that you've heard the testimony of Richard Connor about these text messages, the context of these text messages, and of course what we said here today about the highly probative value of this very, very relevant evidence. The default of this court should be to allow Mr. Zimmerman to present a defense, guarantee his constitutional rights to present a defense, and this evidence is one step in that process. So we urge the court to allow Mr. Connor to testify about these text messages.
Thank you. Response?
Your Honor, the photograph appears to be Trayvon Martin, but they said they offered it for, I can't remember the term he used, but
John Guy is obviously tired at the end of the day, the prosecutor, and he really didn't have any argument. I zipped past it because I just want to get to the end of this, but notice that he just kind of is hesitating and off script, and it's the end of the day, a very long day, and even this guy is lost. Not really lost, but in terms of coming up with as you know, he's very good in his presentation abilities, and he's off his game here right now. And I'm just going to let this play to the end because now the fireworks start.
the best photograph of Trayvon Martin for this jury to consider is the one of him on the medical examiner's table that was taken just shortly after his death.
That's ridiculous.
We don't know if when this photograph was taken. We don't know if it was something that he took right after he worked out and got all pumped up and maybe took a picture of himself for that reason. We just don't know. But the best...
That was the dumbest thing I've ever heard. The state is conceding that the picture is prejudicial because Trayvon Martin looks really buff, worked out, he's lean, he's 17 years old, and he really looks like a fighter and like somebody that would just kick your ass. And so that's why they don't want that admissible or admitted, because it ruins their case that this was just a slim little guy.
Photograph are the ones already in evidence that were taken at or about the time of his death. So for that reason, I see no probative value to the photograph, as we already have that in evidence. Let me just have a moment. Judge, they relied on Chambers versus Mississippi. Again, I don't think the purpose of that is to eradicate and to allow into evidence items that are subject to the type of speculation and misinterpretation that this proposed evidence is. So I would ask the court to continue to grant the state's motion and deny this evidence. Thank you.
Thank you. Any further argument?
Let me briefly point this to the authentication issue specifically. Well, first of all, as to the content of the text messages, they are what they are. I'm not suggesting that we should be allowed to explain them when they're offered to the jury. The jury will see them and give them whatever weight they choose to give them based upon what they believe them to mean. As to the authentication issue, this issue is mired in the mess that discovery on this issue has become.
Here we go.
There is a pending motion for sanctions before this court that will be taken up at the end of the trial because Mr. Della Rianda stood before this court and said, we gave the defense everything. We offered the testimony of Wesley White, we offered the testimony of Ben Credos, that in fact wasn't true. And we finally got the report from Mr. Brenton at FDLE on June 4th. June 4th, and we still haven't had a chance to go through it because we had the Fry hearing, we've had 2 weeks of jury selection, and what is this, our third week of trial? I can't even keep track of time. There is an ongoing discovery issue, violations. In fact, Mr. Guy stood there silently when Bernie Della Rianda said, we gave him everything, there's no other report. We didn't get any information from anybody different than what we gave them. And we know that's just not true. Mr. O'Mara said to this court, let's relax some of the authentication issues, if nothing else, because we can't get through this issue with the timetable the court has set. There is no authentication issue. In fact, the authentication issue that Mr. Guy raises is illusory. And to the extent this court thinks there is one, it's because of the state's misconduct, not because of anything that we've done.
Even if you were to take everything out of that bin file, it would still be the same issue. It's coming from the same phone.
We did not have the ability.
Well,
we were misled, Judge. We were given a.
Go ahead.
Uh-oh.
We were given a report at the same time we were given the bin file in late February. The report was misleading. It did not contain the same information that the state had in its possession at that time. We got the report, which...
Look at the look on Mark O'Mara's face, and Zimmerman. Zimmerman's like, what the hell? And O'Mara is like, he's going, oh, I can see where this is going.
Was incomplete.
Connor testified that he found 600 additional photos that the state didn't know about. So
that's not true. That's just not true.
I thought I heard him say that.
Well, that's what he said, but that's not true that the state didn't know about them. We had testimony before this court from Ben Credos that he printed 2 reports.
We're really side issue because my point being is, if you had 5 years to look at that bin file, it's still coming from this same phone.
We
correct?
Only wanted an
it's
extra week.
It's still coming from this same phone, correct? Yes.
The data set is the data set. Yeah.
These 2 people are actually going to literally do what we call it, which is argument. They're going to start arguing.
Yes.
Okay.
Like husband and wife throwing plates at each other.
It's still coming from this phone. The information that you're seeking now to introduce through Mr. Connor, I do have an authentication issue about it. 90.901 is the requirement for authentication or identification. 901.1a, and I'm reading from Earhart. The most common method to authenticate the electronic record or message is by the testimony of a person with knowledge who created the record or message of that printout accurately reflects the contents that the witness created or said. And it goes on and it brings you to footnote number 3, and it references Griffin versus State, 419 Maryland 343 19 A 3rd 415 2011, and State versus Ellick, ELECK, 130 Connecticut Appeals 632 23 3rd 818, the 2011 case. An electronic document, example, email, text messaging, and networking sites like Facebook may continue to be authenticated by traditional direct testimony of the purported author or circumstantial evidence of distinctive characteristics in the document that identify the author. Typically, electronic messages do have self-identifying features. For example, email messages are marked with the sender's email address, text messages are marked with the sender's cell phone number, and Facebook messages are marked with a username and profile picture. Nonetheless, given that such messages could be generated by a third party under the guise of the named sender, opinions from other jurisdictions have not equated evidence of these account usernames and numbers with self-authentication. They cite another case of Commonwealth versus Prodi, 459 Massachusetts, 442. 945 Northeast 2nd at 372, 2011 case. Evidence that electronic communication originates from email or social networking website that bears purported author's name is not sufficient alone to authenticate it. Another case, they cite emails authenticated not only by defendant's email address, but also by inclusion of factual details known to the defendant that were corroborated by telephone conversations. And my point being is that what has been presented to the court, Exhibit 4 is the profile picture. Exhibit 2 and Exhibit 3 has nothing identifying Mr. Martin. He doesn't say, hey, this is Trayvon, or it has going out to Lavandria, coming back in from Lavandria. It has the phone numbers, it has the time, but anybody could have picked up that phone and sent these text messages. A third party could have access to it. People have children who pick up their phones and play with them and send text messages to their friends or other people. I don't have...
But the problem, people, with that is that there's no evidence of that. And the state, the opposing party, has the obligation to prove that the phone has been tampered with, and it's unreliable evidence. The expert, Richard Connor, testified that the phone had never been tampered with, never been hacked, never been cracked. So the defense can't prove a negative. They can't, when somebody says the phone has not been tampered with, they can't go out and prove that there's no one in the world, like, for example, well, let's go depose all his family, let's go to Trayvon Martin, let's go depose his friends and ask every one of them, did you ever fool with his phone? Did you have access to his code? And go in there and use it for texting messages. If there's none of that evidence out there, then this is admissible on these grounds. So for the judge to say this indicates to me she just doesn't understand technology, and maybe doesn't understand what Mr. Connor just testified to about these layers of security and protection and privacy that Trayvon had installed on his phone, that he installed.
Any identifying marks that these text messages are created by or sent by Mr. Martin. I have a concern about that.
Well, we know the phone had a double level of security. We know that.
And I know any 7-year-old can learn the passwords and get into that because they do it all the time.
MCLE couldn't do it for a year almost. Well, they sent this phone all over.
Now, the judge is just so off on this, and unfortunately Mr. West really takes offense when this judge doesn't make sense. He just gets mad. So and that's why you're about to see this exchange come up. And also notice the judge goes, well, you know, well, the FDLE took a year. Well, so anyway,
The country, and they had to write code for it.
But a person may know that password. Another person may know that password. FDLE didn't know the password.
It's evident under 90.901 that there's evidence sufficient to support a finding that it is what we claim it to be. All of this came off of Trayvon Martin's phone. There are thousands of pictures, thousands of text messages, no indication that anybody else was using his phone. Mr. Connor looked at all of those text messages. Further, under the authority of is it Manuel?
Yeah, it's on the same page.
Manuel v. State, is that the one you're talking about? 357 Southwest 3rd, that one?
Yes.
Cited in Earhart's book, I guess. Mr. Romero pointed this out to me to suggest, I don't know what else we could do under these circumstances when the state didn't give us the information timely.
But
We
even if the
didn't-
state gave you that information, is my point, what on these text messages identify that they were created by Mr. Martin?
The phone number.
Time and the opportunity to find the witnesses on the other end, first of all. And we have not had that because of the state withholding valuable exculpatory probative evidence in this case repeatedly, and then misrepresenting to the court what they did. And then finally, when we caught them doing it, we get it on June 4th.
One final point I want to make, that under this judge's reasoning, nobody could ever be convicted, for example, sending a child porn on their phone. Let's use that as an analogy. Say that somebody gets arrested for sending and receiving child porn. The defendant can't get out of the charge by taking the stand or putting an expert on the stand and saying, oh, well, you haven't shown that my phone wasn't tampered with, that somebody else was doing that. If the state showed, the prosecutor showed, well, no, you had a passcode, you had your password, then you had 2 layers of security, then you had a hidden app, an app that hides everything and then renames files and disguises the extensions. You had all of this stuff. That would be circumstantial evidence to prove that it's your phone and you are the one sending this material. Under this judge's logic, she would dismiss the case for child pornography against the defendant because she says, well, prosecutors, you have not shown that the phone was not tampered with by somebody. And that's exactly what's going on here. The judge says, what proof is there that this was Trayvon Martin doing this texting and having these pictures and whatnot?
Judge, I don't know what else we could have done, frankly. We asked for time. We wanted to depose Steve Brenton. We asked the court to delay the case a few days. I don't know what else we could have conceivably have done under the circumstances to further this authentication issue under the circumstances that the state is solely responsible for. It's simply unfair for Mr. Zimmerman not to be able to put on his defense because of the state's tactics. It was a strategy, obviously, because they had it in January and kept it from us, made us spend 10, 20, 30, 100 hours digging it out, playing games with us, lying to this court, and now it's our fault. It's our fault. To deny Mr. Zimmerman the right to present this information violates both the Florida and the United States Constitution.
Yeah.
Thank you.
Does the state want to respond?
Not in substance, but because Mr. West said, I would offer him the opportunity right now to apologize to me for suggesting that I stood by silently with information that I did not have.
I'm not getting into this. Court is in recess. I will give my ruling in the morning. I'll see you at...
Here's the lawyers adjusting their gun belts, I guess. Isn't that hilarious, the way they're both standing up and adjusting? And Mr. West's belt is crooked, by the way. But look at them both going like, well, and adjusting their 6 guns.
8 o'clock in the morning. Court is in recess. It is 9:56. No, court is in recess. Thank you very much. With all due respect, we'll see you at 8 in the morning. Well, at 8 in the morning, the issue is Mr. Donnelly, who may have violated, or counsel has informed the court that you know that he violated the rule of sequestration. That's the second time today that I've heard that there's been a violation of the rule of sequestration by the witnesses. I don't want to take that up at 9 o'clock and have the jury sit out there and wait like they did today. We will be in recess until 8 in the morning. And so have I.
Not be able to prepare or get my witnesses gathered for tomorrow, and I can't do it tonight.
I'll see you at 8 in the
I'm not
morning.
physically able to keep up this pace much longer. It's 10 o'clock at night. We started this morning. We've had full days every day. Weekends, depositions at night.
there it is.